This is week 3 of a 4-part series, and welcome for those who I haven't met before. My name is Peter Van Roon. I'm Sales Manager Small Business for RBC in the Ottawa regions. We have a team of 14 Senior Account Managers, Business and Personal, who are housed in the various branches throughout the region. We're very proud to be involved with Welch and with Pearly Robson Hill McDougall, all very strong partnerships. Our agenda for today will be Pearly Robertson Hill McDougall. We'll talk about IP rights and as well as some labor law that you have to be very aware of. I'm keenly interested in that. Welch will be talking about many of the government programs that are available, and we have Terry Levine-Way who will be talking about that. The only piece, as far as protecting your business, the only piece really that we at the bank have direct impact on, I would say, would be making sure that your company is properly insured. I'm very pleased to say that most of the entrepreneurs that we meet are very well insured and have got a very competent insurance advisor because they all realize the importance of it. The one piece that I would say you want to make sure that you're aware of is that you always insure your business credit separately, or that you make sure that you've had those robust discussions with your insurance advisor. People can get into lending arrangements with their bank and forget that those conversations or those obligations really should be rolled into your obligations if anything happens to you as well. The last thing, and we've seen it, the last thing you want to leave your heirs or your succeeding partners with is worrying about servicing a loan while you're going through the business of settling up an estate or finding buyers for the business. You want to make sure that piece at least is clean. This takes care of it and is often lined up directly with the amount that you're borrowing. So it's variable as well. So if you treat that as a completely separate line, that's the only advice I would give you from a bank perspective.
My name is Paul Donovan. I work as a lawyer here in the Intellectual Property Department at Pearly's. My area of expertise is on the trademark side. I want to start by just introducing the 3 main areas of intellectual property before I start just throwing that term around. Patent law is dealing with inventions. So if you've come up with a new widget, some device, and it can be in any sort of field, a mechanical device, pharmaceutical, you're getting protection for that invention that you've come up with. Most practitioners in the patent area have a scientific or technical background, which is why I stick to the trademark side. Some of my colleagues here at Pearly's, of course, practice patent law and do have that background. But myself, no, I'll stick to the trademark and copyrights. On copyright, we're talking about artistic works. So it can be a literary work, a film, a song, anything that can fit under that general category of artistic. Software is actually included in the Copyright Act as an artistic work due to amendments to the Copyright Act, so that fits in there. And really it's considered a protection for the author, someone that creates a work. And the last area, trademark, deals with branding, company names, logos, marks that people are using. You'll see some of them on front of you. If you're having a beverage, there'll be the trademark for the particular water or juice that you have. There's an Epson device here that's showing up on the screen. So trademarks are really sort of everywhere, and so my focus is going to be on that because that's my practice. But I just wanted to give a brief introduction to some of the main 3 areas. I'll talk a bit about the process for getting a registration and what are the main benefits of getting a registration. So really, why would you involve yourself in intellectual property and in the decision to file a patent application or a trademark application or a copyright application? And I know particularly when people are in startup phase of a business, costs are sensitive. And there has to be an assessment made as between where you want to spend your money. And you come to real practical business decisions about whether you're spending money on inventory or salaries or research and development or filing applications. I would say as a general rule, think about what your business is doing. So if the real value that you're giving to your consumers is something new, some new invention that you've come up with, it's incredibly important to get protection for that invention, because your entire business model is based on that. And if you don't properly protect it and someone else comes out and is, company B starts to do it, that could greatly affect your business. Same goes for trademarks. If you've really come up with a unique brand that's really important to your business, and heaven forbid if that brand is no longer available to you, your business tanks, then it's important to invest. Conversely, there might be business where the brand name isn't that important. People are really buying the device, and it doesn't matter what you call it. And if someone challenges you and you have to change your name, it's not the end of the world. So it's really just an assessment of your own particular business. If you're opening a pizza shop and you haven't come up with any new particular novel way, there's no patent applications that you're thinking about filing. The brand name may or may not be important, depending on whether you've come up with a unique a branding element. Copyright is inherent when you create an original artistic work. So copyright is a form of protection that's there at law, whether you have a registration or not. You have to meet that standard of it being an original artistic work, and there's case law on that in determining how you can distinguish yourself from previous works so that that's an original work. There is a copyright application process in Canada. It's a very simple, very rudimentary process. You really fill out a form listing the author name, the owner name, title of it, what type of work it falls under. You don't submit an actual copy of the work. The office doesn't assess the registrability in any way. It doesn't compare it to previous works. It's really a form that you fill out. You get a nice looking certificate that you can put in a frame. And what it really helps you is if you have to enforce your rights. When you walk into federal court, you can say, here's my certified copy of my copyright. That's proof of your rights right there. It's always subject to the other party to come and attack you and say, hey, wait a minute, I came up with something 5 months prior to you, but it just flips the burden that now the other guy has to do it. Without a copyright registration, you have to sort of recreate the whole history of how this work was created. You raise an interesting point with works like software, sometimes even in some literary works where it's kind of a fluid work, where there's versions, a 2.0, and things are developing. I would say you're getting protection for the work, so it's not for the idea, it's the actual expression of the idea, so you have to have a work there before you can consider copyright registration. If you've got a version out there and you go and you get your copyright registration, a big issue comes up if you've come out with subsequent versions and it gets modified. At what point can you continue to rely on your existing registration? Unfortunately, there's no magic number or answer. It's very fact specific. As any good lawyer, we can argue on both sides, so it really depends is the answer. But if there's fairly small, insignificant changes that are made, minor updates to the program, I'd feel pretty confident relying on the copyright registration that you already have. If you've made so many amendments, you're on version 11.0 and it's a completely new program, I'd be much more hesitant of relying on that original registration certificate. At that point, you might want to consider getting a separate registration. The main benefit really is, I look at a copyright registration as a form of insurance. It's basically in the event that you run into some sort of a dispute, it makes your life a lot easier. It's not mandatory, so if you're looking to save bucks at a particular time, you don't have to. You still have rights. It just becomes a bit more difficult than when you have to enforce those rights. I'll contrast that. I'll flip to number one, which is the patent process. Patents are purely a statutory right, so registration benefits is you have to do it. If you don't have it registered, you don't have a patent, and it's a process that you have to go through. Patent protection essentially gives you exclusivity, that particular invention that you've come up with for a time-limited period, and that time period varies by country, and so it's national protection. And you can file in one of multiple different countries. Again, from a cost perspective, one strategy, and again, I'm not on the patent side, but what my colleagues have used is, for example, there's in the United States, they have what's called a provisional patent application, and it's basically a short form, simplified version of a patent application where you list sort of some of your details, but not in any great detail. And it's really for the purpose of preserving your priority as against any other third parties. And then you can sort of, if you need to shop around for financing or further develop your product or fine-tune the details. So it's a nice strategy for at least getting your protection, your date in there, with all the details to be filled in at a later point. The patent process, depending on sort of how many countries you're filing in, can obviously costs can add up as you go. But as Canadians, our obvious target markets generally are the States, but then it's very industry specific. You might be looking at Asia, you might be looking at Europe, you might be looking at the Middle East, depending on what technology you're involved in. I'll focus a bit more on the trademark side, which is my main area of practice. So basically 80 to 90% of my day, every day, is preparing and filing trademark applications, dealing with any objections or correspondence from the trademarks office, and seeing those marks through to registration, opposing other marks if I'm objecting to other marks, trying to cancel other marks, dealing with trademark litigation issues. Like copyright, you do have rights in a trademark, even if you don't have it registered. But I'll talk a bit about why you would actually then go through and spend money to get a trademark registration. The main thing is the geographic scope of your protection. So without a trademark registration, your rights are limited to the area that you can prove some sort of a reputation. So the easy example that I give is if you're in the restaurant business and you're in Ottawa, people might know you in Ottawa. But if someone opens up in PEI or in British Columbia under the same name, without a trademark registration, you're going to have a very tough time stopping that person, because the reality is there's no real damage to you. Nobody knows who you are, so there is no passing off. There's no infringement. Contrast to when you have a trademark registration, you get national rights. Whether you're in only Ottawa and nobody's ever heard of you in Vancouver, it doesn't matter. You can shut them down. So that's a primary advantage to getting a registration. It also helps in certain lines of businesses if you're licensing or franchising your mark. It just gives it some validity. You think about it, if you're looking at going the franchise model or licensing to other people, a potential licensee or franchisee knows that you've secured those rights. You've got the exclusivity of that across the whole country, as opposed to saying, well, yeah, we've been using it for a couple years, but we don't have a registration. There's just so many more uncertainties there. So it gives an added value, and that's helpful in dealing with franchisees, licensees, even dealing with potential financial people who want to invest in your money. They see that you've got that, that form of protection in there. It also puts your trademark into the trademarks database, so anyone else who's filing other marks, the trademarks office will cite it against you. The trademarks office doesn't look at the marketplace when they assess whether or not a mark gets registered. They just look at applications and registrations. So it'll help you knock out competitors as well. In terms of the process, so at Purley's, someone like me can help in terms of filing a trademark application. And as I mentioned, we deal with whatever comes up at the trademarks office from start to finish. And that can be objections if you've adopted a mark that's a little too close to somebody else's and you're stepping on their toes a bit, or other types of technical objections, and we'll help see the process right through to registration. In the normal course, it takes about 14 to 16 months, sort of the best guess that I'm giving now. If a third party opposes your application, that can extend it significantly. The trademark opposition process is kind of like a mini litigation. You have pleadings and you file evidence, cross-examination, and written submissions and oral hearing, and it can take years and cost a lot of money, depending on how far the parties want to fight it. So that's kind of the process and the main benefits to each of those types of intellectual property. Just looking at trademarks, I wanted just to talk very briefly about some post-registration issues. And the point I want to raise is that, and I think this would be fair to speak for all of the types of intellectual property, once you're registered, don't just take your certificate, file it away, or if you think it's pretty enough, frame it up on the wall, and then forget about it. The trademarks office will not police your trademark for you. So you've got to keep an eye out for competitors that are potentially using your mark, for people that might be getting a little too close to your name or your logo. You've also got to think about if your business changed or expands. When you file a trademark, you list particular goods and services, but if you've now expanded or you've changed your service offering, you've got to make sure your registration reflects that, so you may need to amend it. And you can do that afterwards. You can file an extension to your existing trademark, but you need to be cognizant of those issues. Even proper marking of your registration. So you'll all see the TM mark, which people use beside trademarks. You can use that whether or not you have a registration or even an application. That's just you asserting a trademark, right? Or MC is the version in French for marque de commerce. The R in a circle is limited to when you have a registered trademark. And it's important if you're in fields like where you're shipping goods to different countries, is you don't want to get into a dangerous situation of saying, I've got the mark registered in Canada, so I'm putting my R in it, and you ship it to Europe and the US and everything else, because then you're representing really that mark is registered. You might need packaging that's specific to each country. So we can help in dealing with those types of issues as well. Trademarks are good for a 15-year period, but can be renewed indefinitely. So you could theoretically have marks, and there are marks that are in the database that are going back to whenever it started in the 1800s was when the registration process started. So that's admittedly a very quick overview. I am happy to answer any questions, and it's really just to give you a flavor for what you're thinking about as to why you would consider going down that route of an application under one of these forms of intellectual property, if that's of particular interest in your business.
My name's Emily Braun. I am a lawyer in the litigation department here at Perley Robertson. I practice general commercial litigation with a focus, and I spend most of my time on labor and employment issues. So that's why I'm here today to talk to you about employment contracts, generally about employment and things that employers would be well advised to look out for in early stages of employment with new employees, and really focusing on how you can deal or make it easier to deal with problem employees when you spend a little bit of time at the beginning of your relationship looking and dealing and drafting your employment contract, because it can make a big difference. If you put a little bit of time in at the beginning, it can really help a lot of headaches, manage your financial exposure on any terminations, and make your decision a lot easier when you're trying to decide if you can terminate someone or not. Employment law it varies by jurisdiction in Canada. So we have a federal jurisdiction, and then we have provincial jurisdictions. And the specific rules, limits, minimums, maximums, they'll change depending on which jurisdiction you're in. So today, since we're in Ottawa, and most employees in Ontario fall under the provincial Ontario legislation, that's what I'm going to focus on. Here are some of the primary statutes that you sort of end up interacting with when you're thinking about your employment relationships with employees. There are others, but the Employment Standards Act, of course, this is the main one. It's the one I'm going to start talking about going forward. It sets out minimum terms and conditions, and then actually sometimes maximum conditions that govern the employment relationship with employees, such as workplace hours, overtime, and really, most importantly, termination as well. There's a human rights code, which applies from the beginning of your first advertisement for a position that you may be searching for new employees, right through to the interview, contracting, and of course during the context of your relationship with those employees, and especially during termination. And then of course there is the Labor Relations Act. That comes into play often to some employers. It sort of affects you in a surprising way, because sometimes employees decide that they would like to join a union, and it's a very steep learning curve for employers who have never really thought about what it would be like to be attached to a union. So that's another area. I'd say these are the three statutes and areas that I deal with most when employers run into trouble with their employees. So as I mentioned, I'm going to be focusing on the Employment Standards Act minimums and conditions. And this is because when you don't have an employment contract with your employees, these are the minimums that we'll be looking at from the Employment Standards Act. Now, it's not to say that this is all you have to worry about, because if you don't have a contract in place that sets out the employer and employee's obligations to each other, the common law also comes into play, which is case law developed by judges that will tell us sort of how some of these minimums can be increased depending on the employment relationship. So it's important to know, of course, there are exceptions from all of the Act, federal employees under federal jurisdictions, other provinces. The most relevant one is students on work experience programs. Often new entrepreneurs who are starting businesses will hire from specialized work programs for students. There's also an exception for inmates on specialized work programs, so if that comes up, that's always something to consider. But it's important to know who it is that you're hiring and to consider whether or not there are any exceptions. as we go along, there are also exceptions. It seems like a relatively straightforward act, setting out minimums and maximums, but there are exceptions to every rule. So I've tried to pick out some of the most important standards that you would generally run into if you don't have an employment contract in place. Hours of work is an interesting one. It's separate and distinct from the requirement to pay overtime. Generally speaking, employees can only work up to a maximum of the 48 work hours per week. So this can be extended. You can have agreements in writing with the employees, but when you're extending the maximum hours, it can only be up to 60 hours. And you actually have to have authorization from the minister that you apply to under the Act as well, if you're going to make them work over 48 hours in the week. There's also a general maximum on 8 hours per day. This can vary depending if you have a non-Monday to Friday type 9 to 5 business. If you have work days that run in shifts, you can also extend that as well. Those need to be agreements in writing with the employees ahead of time. Those do not need to be approved by the minister in advance. But generally, it's good to know that those are the requirements, and to extend them, you need to think a little bit about and plan how you're going to do that in advance. Otherwise, you could be in violation of the ESA and subject to some penalties from the Ministry of Labor. Overtime, as I mentioned, is a separate and distinct from the hours of work. Generally, 44 hours is the most that an employee can work at the regular rate of pay per week. And any amount in excess of those 44 hours has to be paid at 1.5 times their rate. Public holidays. In Ontario, we have 9. Employees are entitled to those days off if those days happen to be on what would otherwise be a regular work day that they would be scheduled to work. Technically, to be in compliance with the Act, you need to have an agreement in writing with those employees in advance if you would like them to work on those days. They have to agree to it because they're entitled to their day off. And if they work during those days, they get their regular rate of pay, or public holiday pay as they call it, plus their premium pay is what they define it as, but that's time and a half again. So important to know that those actually do have to technically be agreed to in advance in writing as well. I have this little note here at the bottom, subject to exceptions. I mean, what would a good law be without a whole bunch of exceptions to give us a lot of work? Generally, all of these requirements and these standards, as well as some on the next slide that we'll get to, any managerial supervisory staff is exempt from these requirements. So that needs to be assessed, like a factual assessment to figure out whether or not they are. Also, information technology professionals are exempt from this as well as a result of some lobbying from some group. And then a lot of other types of work are exempt as well. And not from all of them. Sometimes it's just 1 or 2 of them. So it's worth looking into whether or not your employees might be exempt before you go and try and get permission to have them work past 48 hours in a week or more than 8 hours a day. Again, vacation's an important one. Generally, as most people know, they're entitled to 2 weeks of vacation. Now, this is assuming that it's a full-time employee working. If it's not a full-time employee, there are special calculations that the Act sets out and you can do to figure out how much they're entitled to. By far the most litigated area of the Employment Standards Act and employment relationships in general is the obligation to provide notice of termination. So the Employment Standards Act in Ontario states that all employees are entitled to notice of termination. These are minimums that are set out in the Act, and they are not necessarily what an employee would get if you don't have an employment contract with them. But if you do have an employment contract with them, you can limit their entitlement to what's set out in the ESA. So an employee who's been with you for less than 3 months has no entitlement to any notice of termination, but once they hit that 3-month mark, they're entitled to a full week of termination up until they hit their 1 year. After their 1 year, up until they hit 3 years, it's 2 weeks. And then from then on, it goes 1 week per year completed of employment, up to a maximum of 8 weeks. So those are the minimums that you're looking at. In addition to termination, there's also a provision for severance. So severance is completely separate from the obligation to provide notice of termination. It only kicks into effect when employees have been working with you for 5 years. Some case law has interpreted that to mean even when you have an employee who was with you at one point for a few years, left for several years, and then came back for another couple of years, often they'll be entitled to consider that as accrued 5 years. So just something to think about that I've seen quite a bit recently. So once they have that 5-year employment with you, then the severance obligations, you need to think about whether that's going to be an obligation to pay out on termination as well. Now, it's actually not applicable to many employers because you either need to have a total payroll of $2.5 million per year, or you need to be in the process of shutting down part of your business or closing your whole business and laying off at least 50 employees at once. So severance is not something that comes up all that frequently, but it's something to be aware of. Something that I've alluded to is that it's important to have an employment contract because the minimums set out in the Act aren't always what you can't rely on that's your total obligation to those employees. So when you have written employment contracts, it's an opportunity for you to set out your expectations of the employee reviewing those expectations and agreeing to certain terms on what's going to happen, for instance, in terms of when they're terminated, or what happens when we're in the process of developing some scientific process to do something, an invention perhaps, and who's going to own that intellectual property on termination. So I've listed a whole bunch of benefits here that you wouldn't necessarily get or that would be beneficial to set out in writing in advance if you're just relying on the common law and the ESA minimums. So you can define job descriptions and duties expected of employees. This is particularly important even when you're just setting out a very high-level job description, because when you start dealing with an employee and they become a problem employee, if you don't have it described what it is they're supposed to be doing, or that they should be complying with some of the policy manuals and guidelines that the employer will set from time to time, it's more difficult to establish that the employee is doing something that they were supposed to have been doing. So the other things you can do is provide for a probationary period, which you can extend to quite a bit of a decent amount of time. And in that case, you set out in your employment agreement that you can terminate employees basically for any reason, and you can set out what kind of notice you're going to give them. In terms of this last point, it's also good to clarify what the aspects of compensation are going to be. Often at the end of termination with employees who don't have employment contracts, sometimes they've been subject to informal bonuses or slight increases in pay. And it can become a challenge when there's a disagreement about what kind of notice is required and how to calculate that notice. If we haven't set out what their compensation will be comprised of at the beginning, or in a policy or in a note to file, an agreement as you move along in the employment agreement. So that is something that is very time-consuming to deal with when you're arguing about, are you entitled to a bonus, or what are the regulations that go along with their compensation. Termination provisions, incredibly important. As I mentioned to you earlier, and I think it's worth repeating over again, when you have an employee that doesn't have an employment agreement, upon termination, an employee is always entitled to reasonable notice. And that is typically not the minimum set out in the Act. It is defined by common law, and it will be assessed by courts and argued amongst lawyers how to properly assess that. It's not a red line test or a specific rule. When you look at how much notice an employee is entitled to under the common law, we look at things like length of employment, age of the employee, particular skills or expertise, availability of other jobs in his or her area. A whole bunch of factors will determine how much notice the employee is entitled to, and the idea is to give them enough time to sort of find another job. Because this isn't a fixed, it's not a formula that you can plug these factors into, you can be exposed to, well, the Employment Standards Act minimums say you're only looking at 8 weeks as a minimum. The maximum can be generally up to 2 years of notice, and in exceptional circumstances, it's even been increased beyond that. So the way to mitigate, your risk on and your exposure to litigation and costs of termination of employees is to have a good termination provision in your employment contract, because that is your opportunity to set out your expectations and what notice will be at the time of termination of those employees. So when you address your termination in your employment contract, I always recommend a probationary period, because it gives you a good chance to really evaluate if this employee is going to be a good fit with the organization. The termination by employee, we see this a lot. An employee can leave by giving however many weeks or days of notice. Not required, but helpful for sometimes you then have notice of when they're going to leave. Termination for cause, of course, is always, this is where I'm going to start talking about dealing with problem employees. But termination without cause is the other option to set out in your agreement, and you should have both. So there are 2 types of termination: with cause, without cause. Without cause, you can terminate someone without cause by providing them reasonable notice. So that's either what you've contracted for in your agreement, which you can either incorporate the minimum standards in the Employment Standards Act, saying that you can be terminated without cause in accordance with the minimum standards set out in the Employment Standards Act, and then that would limit you to the approximately 1 week per full year worked. Or you can provide for more. That's obviously a business decision. A lot of these increasing entitlement to the minimum set out in the Employment Standards Act, that's all a business decision, and it often depends on how attractive you want to make your workplace and to retain employees. But without contracting to the minimums or to an additional amount in excess of the minimums, you're going to be subject to that common law notice assessment that I mentioned earlier. Termination for cause, of course, is where we start talking about the problem employee, because termination for cause is a very difficult, it's again not a red line test, and it doesn't happen frequently that one instance of insubordination or dishonesty can lead to proper cause for termination. But it is helpful to have your expectations of the employee set out in your employment agreement ahead of time, and to have policies and guidelines that they should follow, which really make it clear whether or not they're following those. And then you can point to, here's what you agreed to at the beginning, you haven't been meeting those requirements, and therefore developing a case for cause. But when dealing with a problem employee, at any significant incident that causes concern to an employer, what should be done is you should, first of all, always raise the issue with the employee. You need to warn them that something that they're doing is unacceptable, in breach of their agreement or what you expect of them. And a note, at a minimum, a notation should be made and kept in that employee's file. Ideally, you would sit down with them, talk about it, write them a letter explaining everything and what isn't acceptable, and then warn them that further instances of whatever violation they've done could lead to further discipline, because you need to build a file of That's often called progressive discipline. You need to build a file to constitute cause later on. And they need to be warned that something that they're doing could constitute further discipline or dismissal, depending on how serious it is. The importance of building your file will come into play, and warning the employee is particularly important, because if you don't do that, the law often will consider you as having condoned the behavior. And condoning the behavior puts you in a difficult position when you're looking to create your case for cause at the end. Because if an employee was led to believe, or could have reasonably held the belief, that what they were doing, well, it's not really in line with the policies, this employer lets everyone do this, it creates a difficult position to take when we try and advance a case for cause later on. There are other considerations, of course, when you're looking at your employment relationship. Are you doing an indefinite term relationship? Is this a contract-based? Is this an independent contractor that you're hiring? Are you just working for a specific amount of time, or do you want this person on as a long-time employee? Lots of other considerations that I could talk to you about, but I think that will be it for now, and I'm happy to answer any more questions you might have later.
So I'm Terry Levineway. I'm at Welch. I've been at Welch year and a half, I guess, and before that I was with Ernst & Young for 11 years. My focus is, I'm not an accountant, but I deal with our accountants, our clients, to help better understand what the businesses are about. So trying to understand kind of where the business has been, where it's going, and then what's the portfolio of government assistance that's available out there that kind of best fits the business. You know, some questions that we're always asked, or that we're always exploring, is, you know, are you maximizing government assistance to benefit your business in the most valuable way? So tax credits, grants, loans, rebates. Are you reasonably certain that you're going to get that incentive? So a tax credit has some level of certainty to it, more so than a grant or a loan application would have. And then, do you know the timing of that receipt of cash? Is it predictable enough? Can you factor it into your business plans? Can you factor it into your cash flow? So those are the types of things that we consider as we, again, as I mentioned, explore the business, trying to understand better where the business is going, so that we can help you plan for government incentives. So this is just a list of acronyms of various incentives. The point here is that there are so many incentives out there. When you picture this at a federal level, and then you picture it at a provincial level, and then in some cases municipal levels, there's a lot of stuff out there to help businesses. The trick really is what's worthwhile to chase. Everybody's got finite time, finite resources, finite patience. What really is worth it for the business to chase in terms of dollars available? How much work is it to go after? What are the chances of success? And ultimately, how long is it going to take? And it depends a lot on your business as well. So, you know, over here we're talking probably more of an R&D, product development type of business. In the middle, ATC, OID, MTC, there you're talking about more digital media businesses, or ATC would be more of the, you know, your construction, your trades businesses. Things like OPA, EMA, OPA would be more about power efficiency for your offices and your operations. EMA would be more if you're attacking foreign markets. So I want to sell more into the US, I want to sell more into Europe, I want to sell more into Asia. So there are some programs there that can help out as well. So again, this is not meant to be a conclusive list. It's just to illustrate the point that there's a lot of stuff out there, and you really need to kind of get a handle on what's valuable to look at. So as I mentioned, you know, an overview of the business. So this holistic approach to look at the recent past, the plans to go forward. Generally, what you're looking at for tax credits is to look backwards a little bit. For grants and loans, it's usually looking forwards to understand what you're going to do and is there assistance out there. And then, things like rebates would be, in some cases, a combination of the two. Well, we're looking forward to see what we're going to do, but we're not going to get the money back until we've spent the money, so kind of like a tax credit. This line here really is that equation to say, what's the net benefit of what I'm chasing? Here's the potential dollars that we're chasing as a business, but I have to subtract from that any internal costs, time, people. I have to subtract from that any external costs, whether using consultants or have to get maybe you need audited financial statements if you don't have that already in order to support your claims. And then you always have to prepare some sort of application, and in most cases you're going to have to defend an application too. So there's a lot of costs there. Some are more explicit, some are a little nebulous to get your mind around. All that to say is when you're dealing with government money, it's never quite free. There's always going to be something attached, whether that's additional work or whether that's really a cost outlay. It's never quite free. Could be really cheap, but it's never quite free. And as part of the holistic approach then is making sure, as you understand what incentives you're going to chase, that you start to incorporate the evidence that you need for those incentives on, I'll call it a real-time basis, but I don't mean day by day. I mean, maybe it's quarter by quarter or month by month, that you're tracking the evidence that you need to support those claims. It's a lot easier to do it as you go than it is looking back 12 months, 24 months, what have you, to try and see what evidence did we create to support that stuff. Knowing what you're fully entitled to, if you're approved for a grant, if you are claiming an R&D tax credit or any other tax credit, there are a lot of misconceptions out there, and people just generally, or naturally rather, by having a finite amount of time, they go with, well, this should be eligible. I should be able to claim this, or this is what I've done in the past, so it must be the way it is in the future. But these things are changing, and while tax credits and tax legislation changes slowly, what changes a little more quicker are administrative policies, the way auditors view certain types of expenditures, and then they start to approach things differently. And for SR&ED, if anybody's familiar with SR&ED, we are seeing some winds of change there. Not only are there changes on the form, there have been recent changes in legislation, and now there's different auditor behaviors creeping in that we see in a number of claims around town. So that's an example of something where, again, maybe slow and steady change over the last few years, but all of a sudden you've been going along, I've been doing it this way, this way, this way, and then all of a sudden you get hammered. And we are seeing things like that. So there's misconceptions, misinformation, or just relying on past knowledge can sometimes get you into a bit of trouble. Know the rules for each incentive. Know what you can claim, what you can't claim. And then what that leads into is maybe some opportunities for stacking. So as I spend $100, how much of that $100 can I get back? Can I get back 10? Can I get back $60? When you take something like a grant with an SR&ED claim and a digital media tax credit claim, maybe I've got some co-op students in there. How does that all factor together to make sure I get the most of those dollars back? When it's something like a tax credit, you are entitled to that if you meet the criteria. It's in the tax legislation. So, we're not looking to bend the rules by any stretch. We're saying know the rules so you can understand what you're entitled to. Another interesting thing is when you get a government assistance, so again, whether it's a grant or a loan or a rebate, what impact does that have on your tax credits? And the government, to their credit, they've been getting creative in how they structure some of these government assistance things. So it could be a full-out grant. It might be a repayable loan, but it's not repayable for 5 years. And then when you repay it, it's without interest. So there's been different creative ways, especially since the stimulus budgets back in 2007, 2008. That's had a real, it's forced us in the business to really stop and think, okay, well, does that count as government assistance and reduce aspects of these other tax credit claims? And frankly, it's been a little tricky to really find out what the position should be. And we've taken different positions at different times because the fact pattern is different. So that's been a very interesting one where, again, the common one that we've been dealing with is, well, it's a repayable loan, but it doesn't start for, I think, 3 or 5 years, and then it's repayable without interest. How does that impact a tax credit claim that I'm making today? Not always straightforward. And I think I've covered some of this already, but again, tax credits are, I guess the certainty of the existence of the tax credit is there, but not necessarily the certainty of the outcome. So a tax credit founded in legislation is something you're entitled to if you meet the criteria, but you do have to still go through the processes of claiming and potentially an audit. So what we see lately is quite a large variability in terms of when your R&D claim or your digital media claim, for example, are coming in. So a digital media claim right now, whereas 2 years ago maybe it was 6 months, right now it's probably closer to 18 or 20 months to hear about. An SR&ED claim, if you're a first-time filer right now, it's kind of hit and miss. Some first-time filers are hearing within 6-8 weeks their claim is approved, and we've got other first-time filers that are probably 6 months into their audits right now. So highly variable, and probably something, at least in my time doing this, haven't quite seen that variability with, say, first-time claimants. It's, well, I don't want to be dramatic and say unprecedented, but it's definitely curious at this point. Now, discretionary incentives are, again, you hear about a grant. I don't know if anybody's familiar with SDTC, for example, but it's an organization that offers grants to companies who are building products that are for clean air, clean land, clean water. Using that one as an example, you put your interest forward in terms of an application. If they like what you've described, then you're invited for a full application. After they look at your full application, then you're invited to a term sheet. So it's a multi-stage process. After you go through all that, you're looking at 0 to 12 months to actually have an agreement whereby they will actually give you some funding. Very competitive landscape, and akin to kind of putting your resume into a company to see if you're going to get a job. It's really based on what you, the best foot forward. And it's also a huge lead time. So that's why I say when we go in, you take a holistic view of the business and trying to understand, well, what's going to happen 12 or 24 months from now? Because if you want to seek government assistance for a project that you're going to start, you can't seek assistance today expecting to get it next month. It's just not going to happen. Not only that, as these programs kind of pop up and disappear very quickly as budgets allocated, they allocate the money to companies very quickly, and then they sit back and see how it takes, and then they add more budget. So on those ones, again, they're very lucrative because they're very cheap money, but you have to examine the risk reward of chasing that, and do I have enough lead time in order to actually get some money in time. Tax credit, it always ties into your corporate tax compliance activities at some point. So it's at some point always going to be an annual activity as opposed to something discretionary. Generally has no bearing on your tax year ends or what have you. It's really can, like I say, pop up. Here's an opportunity, and then it disappears very quickly too. There's lots of stuff going on, and there's lots of little pockets here and there to be looking. And IRAP, for example, all of a sudden you hear 1 week IRAP's got money, the next week you hear IRAP has no money. And it almost depends on who's asking. So there is definitely government assistance out there. Maybe significant is a bit of an exaggeration right now. I think back to stimulus budgets, there was a lot of money flooded out there. It was relatively easy to get from a government assistance perspective, and now I think kind of retrenching and seeing how much that's helping the economy. But there is assistance out there when you look at it, again, provincially, federally. If you're doing things internationally, there's help out there. Know the rules for the things you're chasing, or get help to know the rules. Look for the best net results. But in my mind, whether it's a tax credit or a discretionary incentive, plan ahead. Know what you're going to go after, plan for it, track it, and you'll have a lot easier success, like I say, than trying to look backwards on it.